you please rise and join us for a pledge of allegiance to the flag. I pledge allegiance to the flag
Allegiance to the flag of the United States of America
and to
and to the republic for which it stands,
one nation,
nation, under God, indivisible,
liberty and
with
justice.
liberty and justice for all.
Danielle, would you please call the roll?
Mr. Bongiovanni,
Here.
Mr. Duncan,
Here.
Mr. Gaffney, Mrs. Crock,
Here,
Mr. Ray, Mr. Riley, Mr. Toppin,
Here.
Mr. Taylor,
Here.
Councilman Schindler,
Here.
Mayor Francis,
Here.
Mr. Gilbert.
Here. Minutes. The minutes of our previous meeting, June 1st, 2021, were distributed. Are there any additions or corrections to the minutes? Seeing none, I will entertain a motion for acceptance of the minutes.
Motion to accept the minutes.
motion,
Second.
Mr. Bongiovanni,
Yes.
Mr. Duncan,
Yes.
Mrs. Crock,
yes,
Mr. Toppin,
Yes.
Councilman Schindler,
Yes.
Mayor Francis,
Yes.
Mr. Gilbert.
Yes. No continued applications tonight.
Yay.
We have a couple of new applications. First is Nancy Marinaro, Block 30208, Lot 2, 130 Bell Avenue. The applicant would like to subdivide this lot into two conforming lots. Is someone here to represent Ms. Marinaro? Where is Ms. Marinaro here?
Here.
Okay, you want to raise your hand, please, and be sworn in by our attorney?
You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And your full name again?
Nancy Marinaro.
And are you the property owner?
Yes.
And I'm Rudolph Holzman. I'm the engineer for the applicant.
Okay, you want to raise your hand and be sworn in, please?
Mr. Holtzman, you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
You are currently licensed in the state of New Jersey?
yes.
Here. And have you testified before boards in the past?
I've testified in front of numerous boards in the state of New Jersey, yes.
Okay, is there any objection to accepting Mr. Holtzman as an expert witness?
No.
Seeing none,
No.
I will do that. We will accept you as an expert witness. So either Ms. Marinaro or Mr. Holtzman, you want to go over the application with us?
Yes, I'll start. The property, as mentioned, is known as Lot 2, Block 30208. It's an R1 zone, and basically it's divided into two conforming lots, conforming with the borough zoning schedule, and for single-family residential use. The site is currently undeveloped in a northerly direction, and is not encumbered by any to verify that information.
Okay. Are you in receipt of the letter dated May 11th, 2021 from Mr. Rushke?
Yes.
Okay. Do you have any comments or questions about his letter, specifically the 13 points in the technical review?
There's a few items I'd like to discuss. Mainly the proposed sanitary sewer connection. We showed a different.
At number 5?
Correct, right.
Okay.
For lot 2.01, what we considered is connecting to the existing sewer in Ford Avenue as opposed to Bell Avenue. The reasons for that, even though it's a longer run, was to avoid going uphill and producing a deeper cut and opening up Bell Avenue roadway. So that's why we showed it at Ford Avenue. So that's something that maybe we could discuss, that comment.
John?
Yeah, did you check the elevations? Because, we try to avoid unconventional situations, and for you to install, that a 200-foot lateral in within a paper road and crossing another property, it's just, we try to avoid these very unconventional, proposals. If it's feasible to extend to Bell Avenue, if it's practical and it can be done, my preference would be to install it, the way it should be installed is extending it to Bell, because that's where your sewer is frontage.
Yeah, I think it is feasible, and after considering both, I mean, I will agree to revise the plan for the Bell Avenue connection.
Okay, thank you. Are there others?
The other one is we don't intend a variance, but I think there is possibly variance associated with the improvement of Richards Road. The intention of the application is to have the developer improve a portion of Richards Road up to RSIS standards. And so that's something we could discuss.
Yeah, but are you going to comply fully with RSIS? If you are, then you have to build a cul-de-sac, and I don't see how are you actually proposing that?
Not to that extent, no.
Then you're not meeting RSIS then.
For width, we intend to. Yeah, for not the cul-de-sac portion, no.
Well,
We have a letter here from Mr. Haggerty also,
Okay.
dated
Yeah.
June 11th. Are you in receipt of that?
yes,
Yes.
Go ahead, Bill.
looking at the statute, what the statute provides is no permit for the erection of any building or structure shall be issued unless the lot abuts the street giving access, an improved public street. So what's going to happen is when that lot is proposed to be developed, whoever is going to do that will have to come to provide proofs to satisfy the statutory standard that the proposed improvements will furnish a safe access for emergency vehicles. Now, you didn't notice a variance tonight, which is okay, but in the future, when that lot's to be developed, there will have to be an application to the board to make that demonstration. That doesn't, in Mr. Rushke's comment, that won't necessarily involve meeting RSIS standards, because it looks like, you're really only going to have two lots that are going to use that road for access. But that would be up to Mr. Rushke.
Again, I don't have a problem with them asking for a variance. We've had many applications where, they have that same variance where they construct a driveway within a paper road. And then we typically as part of that variance, we ask for a condition that a developer's agreement be established and that it's documented that the town is not responsible for maintaining that driveway within the municipal right of way. So it is done, but it's just, the applicant then has to recognize that they're looking for, sell off these lots, that's clean lots, variance free. This one's not going to be variance free. It's they are going to have to come back to the board to get approval to construct that driveway within the municipal right of way.
There's no indication that the site would present problems that might not allow that to happen, though, from what the testimony.
No, I don't think that that is an issue. The only issue that I have is that this is a subdivision and they are representing that they're not a major development, that they're not disturbing more than an acre or increase the amount of impervious by a quarter of an acre. And that is something that we have to put some type of controls if that is in fact what are subdividing this as, because it's not you subdivide and then you're looking at each individual lot. You have to look at these two lots together, plus the work that they're doing in the right of way to satisfy that requirement. So if they're proposing not to do that disturbance, and that probably has to run with the lot regarding, that restriction.
Mr. Holzman?
Yeah, the intent is certainly to keep it minor development. And I'm not, the roadway disturbance and coverage, we could measure that. I'm not certain if it would be included in the 2-lot subdivision.
Now, you include it as a total. This is a project, so it's total disturbance. So, I ran with this with the DEP already. It's all the improvements associated with this project. So it's not just all individual lots, it's both the lots plus any offsite improvements you have to take into consideration for that disturbance limit.
Yeah, we could keep it under an acre, and we could make that a condition for this application.
Okay, so you're going to have to identify exactly the amount of impervious that's being added within the municipal lot, within the municipal right of way, and then look at that impervious coverage. Whatever's remaining, subdivide that between the two lots, and that's what you have to do in order to satisfy that requirement.
Yeah, we did consider that and laid it out that way. With the roadway improvements that you see, including the roadway on this application, we would meet those standards to keep it keep it a minor development and not a DEP major development. Yeah, for stormwater purposes. So we did measure that. It's included on the plan on note 8. So
Yeah.
we did consider it as one project.
And again, just I'm being a little anal on this, just so the board is aware that NJDEP does audit municipalities, and they do look at land use applications to make sure that we administer the stormwater regulations properly, because we're obligated to do that under our municipal stormwater permit. So, they look at these applications and there is no interpretation other than what's stated in the regulations. So, and if we don't comply, then the town is the one who gets a summons or a violation of incompliance with the stormwater regulations. So that's why I'm being a little anal with this one, because someday I may be in front of the DEP explaining this application and why we permitted what we permitted. And so it is again critical that if this is you're trying, and I understand why you're not doing the major development, because you don't want to spend that added expense of designing the stormwater improvements to meet those requirements, but that's coming at a cost to you that is going to have to now deed restrict these properties to minimize the amount of impervious coverage on each lot.
And that's going to have to be a condition of the approval as well.
So John, the condition would be that there will be less than 1 acre of disturbance and less than 1/4 acre of impervious coverage?
Correct. Between and ultimately the applicant, I believe, should be telling us how he wants to have that condition written, because he's going to identify what's that disturbance and what's that impervious in the right of way, and then that remaining amount of area that can be disturbed and your remaining amount of impervious coverage basically has to be subdivided between these two lots. So ultimately, I think it would be appropriate for him to tell us how he would propose that condition.
Okay, Ms. Marinaro, you understand that?
Yes.
Okay. And are you prepared to do that at some point?
Mr. Marinara's here also, so I guess I guess you should swear me
Well,
in.
you're going to have to be sworn in first.
Yeah, sure.
Yeah.
Bill, please.
There we go.
Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? And your full name, sir?
Frank Marinaro.
I'm sorry, we didn't get your first name.
Oh, sure. It's Frank Marinaro.
Thank you, sir.
Oh, you're welcome.
Okay, what did you want to say?
Well, I guess, what the plan was when we worked with the engineer and such is that we would be looking at, obviously being conforming. We were looking at like a home, approximately 2,400 square foot, if I remember correctly, and Rudy can correct me on that. There's a certain amount of, I guess, between the driveway and the home that is allowed. That was a part of the plans that we submitted.
Right.
So,
But we're talking now about the Richards Road improvement.
correct. Right. So each lot, we would be looking, what the engineer maps that we sent in and such, each would be a 2,400 square foot lot and driveway, house and driveway.
Yeah, the 1,200 square
I
feet.
could clarify. The footprint is 1,200.
I'm sorry. Yeah.
For the footprint of the house. And what we did, we worked in that number, in consideration of the Richard Roads improvements. So the condition that the whole entire project is, the right-of-way improvements and the lots are all looked at together. We're fine with agreeing to that condition and don't feel the need to modify the size of the house with the driveway based on our proposed right-of-way improvements.
But the board, it's not a matter of, you're not even proposing, what you sell this lot, unless you're going to deed restrict this house to be 1,200 square feet, that's not what necessarily will be proposed.
Right.
You're just selling the lots and then someone's going to come in with a block grading plan and build what they want. So what we need to do is not necessarily, or I don't think you want us to, is restrict this development of this property to a square foot house. We need to deed restrict it from a maximum impervious coverage, which would be the driveway, the dwelling, patios, whatever. So, if you take the 1/4 acre, and this is just frankly very arbitrarily, if you take the 1/4 acre, and just divide it by 3, basically you're taking 3,600 square feet for each lot and then the right of way. I'm not sure if you need 3,600 square feet but you need to tell us that. So we need to put a number that the maximum amount of square impervious coverage on this lot is going to be X.
Mr. Rushke, then we have to calculate what the impervious coverage would be for Richards Road and determine that net. And then
Correct, and then just divide it by 2. So do you know how much impervious, I'm talking to the engineer, how much impervious is going to be added to the municipal right-of-way?
It's not a significant amount. I don't have the exact number right in front of me. I could certainly calculate it and provide it. It's already some improved paved area there, and we took that into consideration when we proposed the development for lots 2.01 and 2.02. On our plan, we have for lot 2,160 square feet, which is significantly less than the allowable.
Okay, so I guess you will do those calculations. The board can consider this application, and the condition of approval is we can revise this and finalize it with a resolution, but ultimately you're going to calculate the amount of disturbance that's going to occur within the right of way and also the amount of impervious coverage, and then take those numbers and then calculate the remaining amount that to be applied to both those lots.
I could provide that on a plan, yes, for your review upon.
Okay,
yeah, as a
so then
condition.
just so that is what you're agreeing to, and then the numbers will be finalized and we'll work that out, within the resolution itself. But in theory, that's what you're proposing, and that for the board to consider.
Oh, Okay, thank you, Mr. Rushkey. Mr. Holzman, do you have anything else?
No, I think we, all the other comments, I think we've addressed and agreed to. I don't know if the board wants to go over them one by one, but I think,
Rarely. Okay. Mr. or Mrs. Marinaro, do you have any other comments?
No, no comments. No further
Okay.
comments.
Does anybody from the board have questions? Any questions at all from the board?
Yes, I do. Well, we're talking about pervious and impervious. I would ask the engineer if he considered using pervious pavement or pervious technology on the, particularly on the driveways on the lots. That would make a significant difference. And
Well, again,
from my
Mayor,
understanding, with
we're-
conversation with the DEP, they're starting to acknowledge that.
Wouldn't that depend upon when somebody comes in and
Well,
makes a proposal to build a house?
No, we're talking about pervious and impervious, and first the issue I heard was disturbance, and I understand that. Second issue I heard was pervious coverage.
Okay.
Mayor, if I can, and Mayor, I think we
Well,
have,
my question is, if you use pervious technology, that would improve the.
Mayor, I understand your
is if you use
question.
pervious- Yes, so what's
Okay.
our issue with that?
Our issue with that is that, and you may recall the discussion that we had regarding adopting our stormwater control ordinance, is that we need to comply with state statutes regarding the stormwater control ordinance. However,
Correct.
we regulate our own zoning. So where there's a little inconsistency when we're evaluating major developments for consistency with our stormwater ordinance, and again, complying with the state requirements versus zoning requirements. So, they can certainly do impervious pavement and different things for compliance with our zoning regulations.
Yeah.
When it comes to compliance with our stormwater regulations, we need to follow the state. We don't want to be very frank, the Mayor, we don't want to have to incur fines because we're giving this applicant leniency. We don't want, the borough should not be in that liability. So, and we can fight the DEP in another day. I'm always up to putting the gloves on and fighting the DEP over this issue, but that's how our regulation reads right now, and that's what we have to comply with. So I think we should be enforcing the ordinance the way it's written, the stormwater control ordinance. And, we have that latitude written into the zoning regulations because we don't look at, we take impervious pavements and such. We exclude that when we're looking at, our impervious coverage calculations. But for stormwater, only for stormwater with major developments, is that we don't consider that.
But this is not a major development, correct?
Mayor, they're saying it's not a major development. And so if we want to then say that we're not going to consider impervious coverage under our zoning regulations, that's not the same when we're evaluating this for major development. I will fail and the borough will get a summons.
yeah, I'd like to add that, yeah, the driveways here, we're not proposing as part of this application, any pervious pavement. That would be up to the developer if they wanted to do something like that. But
and the storm, when we're looking at the individual lot grading, they can use pervious pavement and they can use different things to mitigate stormwater, comply with our local zoning regulations. And then we do accept that and we acknowledge that.
Okay, I got it.
Yeah.
I got it.
We just need to protect the borough's interest on this, Mayor.
Yep, I got it now.
Okay, anything else from the board? In that case, I will open it to the public. Would anybody from the public like to comment or question this application? If so, please go to the bottom of your screen and in the reactions, raise your hand. Seeing none, I will bring it back to the board. Ron, you didn't see any, did you?
Nope.
Okay, seeing none, I'll bring it back to the board. What is the pleasure of the board at this time? Would anybody want to make a motion?
I'll make a motion that we approve it with conditions as per our engineer's recommendations.
Okay.
Second that.
I'll second that.
Danielle?
Mr. Bongiovanni,
Yes.
Mr. Duncan,
Yes.
Mrs. Crock,
Yes.
Mr. Toppin,
Yes.
Mr. Taylor,
Yes.
Councilman Schindler,
Yes.
Mayor Francis,
Yes.
Mr. Gilbert.
Yes. Okay, we will move on then to the next new application, which is by Frank Manero.
This is going to be like deja vu all over again.
That's correct. 30.
Hey, can I make a just, Alan?
Applicant would
And
like
this,
to subdivide this one into 2 lots.
hey, Alan, can I make a brief comment? This is to Mr. Haggerty.
Yes.
I know Mr. Marinaro came in late, but should not the application and all the drawings reflect everybody that would be testifying in this meeting? Because right now the drawings and everything say Frank, that was great, but we had Miss Marinaro there and I was like, okay, where's Frank? Because he's the one that's on these drawings in the application that says they own it. It's a cleanup more than anything.
That was me.
Danielle?
I put the wrong drawing up.
Oh,
Okay.
That was me.
Okay, it's just a matter of cleanup is all it was. So we got one person testifying that's not on the drawing and
No,
That
I
don't
have
look good.
Marinaro on both of them and I pulled up
Right.
Frank's instead of Nancy's first.
okay,
This-
cool,
My bad.
all right.
This one does not have frontage on an unimproved road. So first of all, Mr. Marinaro, who are you're going to testify? Who else is going to testify on your behalf?
I will have Rudy Holzman speak for me again on this
Okay.
situation also.
Let's swear them in again, Bill.
yes. Please raise your right hand. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Oh, you are the property owner.
Yes, I am.
And Mr. Holzman has already been accepted as an expert witness, and we will continue with him as an expert witness. And Mr. Holzman, are you in receipt of the letter for this one, also dated May 11th, which had, I think, 11 technical review points?
Yes.
And are there any technical review points that you disagree with or want to comment about?
No, this lot is very, this subdivision is similar nature, obviously. The difference being the roadway's improved
Right.
on this one. Topography is the same size houses and driveways are proposed on this subdivision. And we had a chance to review all the technical comments and take no objection to any of those.
Okay. Mr. Marinaro, do you have any comments to make?
No, I don't.
Okay. Anything from the board? Any questions, comments from the board? Seeing none, I will open it to the public. Would anybody from the public like to comment or question this application? Anything at all about this application? If you do, please go to the bottom of your screen and on the reactions button, raise your hand. Seeing none, I'll bring it back to the board. Let me ask a question before I go to a motion. John, were the sewer connections on this one okay?
Yes, yeah, they're fine with this one.
Okay. All right. Would anybody from the board like to make a motion?
I'd make a motion that we approve it based on engineering technical review, meeting the engineer's technical review.
Okay.
I'll second that.
Danielle?
Mr. Bongiovanni,
Yes.
Mr. Duncan,
Yes.
Mrs. Crock,
Yes.
Mr. Toppin,
Yes,
Mr. Taylor,
Yes.
Councilman Schindler,
Yes.
Mayor Francis,
Yes.
Mr. Gilbert.
Yes. Mr. and Mrs. Marinaro and Mr. Holzman, thank you very much for attending tonight, and you have the approvals.
Thank you for your time,
Thank you for your
everyone.
time.
Appreciate it.
Our pleasure.
Take care.
Okay, next we have the Duran Project, Lola's Restaurant, Block 70111, Lot 1, 300 Lakeside Avenue. First, we have correspondence on this from Bernd Heffley, who is the attorney representing Lola's. I'll read it. Danielle and I had a conversation with Board Attorney Bill Haggerty wherein we agreed that to avoid any jurisdictional issue and/or arguments, we would carry the application to the next meeting. Please accept this correspondence as our official request to have the application carried to the July meeting. The applicant consents to extend time within which to act as necessary. Thank you for your continuing courtesies and consideration. That is from Mr. Heffley, the attorney for the project. I would like to make a couple of comments before we go forward with this. The only application which is before us, which will be before us at the next meeting, if this is approved, will be for moving the dumpster and for the awning above the deck at the restaurant. No other considerations will be taken at that time. So if there are any problems with music, if there are any problems with parking or with road congestion, they need to be taken up either with Mr. Donegan, who is our code enforcement official, or with the mayor and council. We as a group will hear only the application when we get to it. Bill, do you want to say anything?
Chairman, there's also a aspect of this relocating a parking space. I think you didn't say that, but carried, it will be with notice because one of the jurisdictional questions is in regard to the validity of the notice that was provided. So there will be notification again as to all three properties. There will be consent filed as to each property owner. We cannot go into the merits of the application tonight. We discuss the application beyond this request. So public comment will be coming in July, I'm convinced, but tonight, the only thing we're talking about is whether to carry this to July.
Okay, thank you, Bill. So would a board member like to make a motion to carry this until the July 6th meeting with notice?
Well, that's the first meeting? Okay, all right.
I'd like to make a motion to move it to the July meeting with notice.
Okay. Is there a second?
Second.
Mr. Bongiovanni,
Yes.
Mr. Duncan,
Yes.
Mrs. Crock,
Yes.
Mr. Toppin,
Yeah,
Taylor,
Yes.
Councilman Schindler,
Yes.
Mayor Francis.
Yes.
Mr. Gilbert.
Yes. I would like to mention at this time, I will not be at that meeting. I may be in attendance, but I will not be participating because I'm having an operation that day. So Ray will have to take care of that, or if Bob is not here, we'll have to elect somebody to take care of it. So now those of the public who are here and want to comment on this, I have to skip you at this point. We cannot discuss anything that has to do with this application at this point. There will be a time later in the meeting where I will open the meeting to the public for any issues at all. At that time, if you would like to mention something, you may. So
Would that include when notifications go to the property owners? Would that be covered at that point?
Yes, everything.
Oh, the notices have to go out, be sent 10 days ahead under the statute. So he has send the notices out 10 days ahead.
But the notices from prior meetings list property owners that are not within 200 feet. And I do live within 200 feet and have never gotten a notice prior to this
He is
notification.
required to send notice to the owners on the list to be provided by the tax assessor. So he relies on the tax assessor's list that's provided, and that's what the statute calls for. But now you're aware that we're talking July 6th.
And can we make sure that there is notification to
There
the
will be
proper
notification to
people? Because the
everyone.
February one was not to me.
Yes, you can contact, I believe the attorney for the applicant's probably here. The tax assessor can be contacted to double check that list to make sure it's accurate.
Right, that would
John,
be Heffley.
Mhm.
Bill, we need to move this to the public comment. We're getting deep.
Yes,
Yeah.
yeah, let's move on. Zoning officer report. Bill Donegan, do you have anything for us?
Nothing this evening.
Thank you. Resolutions. Klaus Bennert, hearing date, May 18th, 2021. This has been distributed electronically. I assume everybody has had a chance to read it. Are there any additions or corrections to the Bennert resolution? Seeing none, I will entertain a motion for approval.
I move to approve it.
Second?
Danielle?
Mr. Bongiovanni?
Yes.
Mr. Duncan?
Hey.
Mrs. Crock?
Danielle, I apologize. I need to abstain.
Okay,
I was not at that meeting.
okay. I had you were. Mrs. Judy?
Yes,
Thank you. Mr. Toppin?
Yes.
Mr. Taylor?
Yes.
Councilman Schindler?
Yes.
Okay,
Okay.
is that it?
Yep.
Okay, let us move on then to correspondence.
Oh, wait, Alan?
Yes.
There was an addendum with a second resolution for Jarozinski.
Oh, yes. I thought I printed it out. Okay, let's go over that one. What was the meeting date on that one here?
May 18th.
That was also May 18th. That was also distributed electronically. Are there any additions or corrections to that resolution? Jarozinski. Okay, seeing none, I will entertain a motion for approval of that one. Somebody want to make a motion?
May
I'll make
18th.
a motion.
Yeah, I'll second it.
Okay.
Who made the motion?
Taylor.
Thank you. Mr. Bongiovanni?
Same.
Mrs. Crock?
yes,
Mr. Toppin?
Yes.
Mr. Taylor?
Yes.
Mayor Francis?
Yes.
Mr. Gilbert?
Yes. Okay.
How about- Don't
correspondence.
I get the vote?
No, you voted no for the application.
Oh, okay.
Go there.
And actually, Danielle, I seconded it, so
Yeah.
can I even say that?
Can we,
Want to second it?
No, we should have revote it.
do it over?
Second.
It's a mulligan.
All right, I need a first and a second.
It's a mulligan.
Okay, we have a motion. Somebody want to second the motion?
Second.
Who made the first?
Me. Mr. Taylor.
Okay.
Taylor did.
All right, Mr. Bongiovanni,
Abstain.
Mrs. Crock,
yes,
Mr. Toppin,
Yes.
Mr. Taylor,
Yes.
Mayor Francis,
Yes.
Mr. Gilbert.
Yes. Okay, now we'll move over to correspondence. I do have correspondence from the Lake Hopatcong Commission that has to do with Lola's. That will have to wait until the next meeting. As usual, it's just hearsay, but if somebody wants to show up and speak about it, that would be fine. Bills, shall we pay the bills?
pay
Please,
the
pay the
bill,
bills.
please.
Second.
Mr. Bongiovanni,
Yes.
Mr. Duncan,
Yes.
Mrs. Crock,
yes,
Mr. Tappan,
Yes.
Mr. Taylor,
Yes.
Councilman Schindler,
Yes.
Mayor Francis,
Yes.
Mr. Gilbert.
Yes. At this point, I will open the meeting to the public.
There.
Anybody from the public who wants to ask the board questions or make comments about anything other than Lola's Restaurant. We cannot discuss anything that has to do with Lola's tonight. Go to the bottom of your screen and in the reactions, please click and raise your hand. Oh, that
Ms.
was
McKenna?
Ms. McKenna.
Yes.
You want to raise your hand to be sworn in by Mr. Haggerty, please?
If you're going to provide some testimony, or do you just have a question?
No, I have a question about the notifications.
Well, I thought we answered that. Did you?
I just want to have a clarification on how that notification list will be corrected and I have a question about whether or not it will impact going back to previous, the preliminary and final site plan, which I never had notice about.
No, it does not. He relies upon the list from the tax assessor. If for some reason your name is not included on that list, it is not the applicant's fault. It is some deficiency within the office that does not lead to your name being included.
I just want to point out that on the one from February that I have in front of me, which I was kindly directed to get online, which was very helpful. Thank you. None of my immediate neighbors are listed here. So it's not just me who didn't get notice of at least that.
I would suggest that someone go into the tax assessor's office and look at how they generate the 200-foot list. They're supposed to do it from the extremities of the property and just see what's going on there. Because as I said more than once, the applicant relies upon the list which is generated by this office.
And the beginning part of that sentence was, who's supposed to go into the tax assessor's office?
Well, the tax assessor
Feels that they should be on the list.
you could have the tax assessor
No.
check to make sure it's okay. Because
Am I
Mr.
allowed to ask what address it is? Because I have the list in front of me, or is that, no, we have to wait till they're present?
Heffley is going to need to get that list for the other two properties, which is going to include almost all of it's going to be an overlap, I'll put it that way. And the assessor is going to have to generate lists for those other two properties. And we're only talking about the restaurant property tonight, but the assessor, it'd be a good thing to contact the assessor and say, please double check the list.
Yeah, because they're at 300, I'm at 304. And never got notice.
Both of
Okay.
them are on the list.
They are?
Well,
Okay,
for this meeting, yes. Prior meetings, no.
That's all we're talking about this meeting. We can't go back to prior meetings.
right, we
And
can't go back.
And we won't. Mhm.
Okay, Ms. McKenna,
Thank you.
you're welcome. Somebody else's hand was up a moment ago. I don't see it. It was SHAYRMS.
Yeah, they were there and they left.
Okay. Would anybody else from the public like to comment on anything at all? Or ask the board any questions at all?
Oh, there we are. Here we go.
Okay, go ahead.
Back.
Okay, SHAY, Ms. Shayrams. So, you're muted, ma'am.
You're muted.
Unmute, please. There you go.
I took my hand down because you said that you can't go back. My question was, how many meetings were before this one that we weren't notified of?
Well, that we don't know. We can only go forward.
This is the first meeting on this application.
But you spoke of a February meeting I was not notified of. How many meetings were there?
This is a brand new application.
This is new.
I mean, if you want to look back to the minutes of any previous meetings and see what we discussed, that'd be fine. But this is a brand new application and it has two items: the movement of the dumpster and the
Awning.
temporary cover over the dock or over the upper deck.
Okay, so I just want to clarify regarding the things that you wouldn't hear tonight, the parking, garbage, noise, those have to go. How do we move forward on those items?
You call Mr.
Because the
Donegan.
police have told me there's nothing they can do. So
You
what
call
are you supposed to do?
You call Mr. Donegan, who is our code enforcement official, or you contact the mayor and council because some of those items may be in their purview. But I would suggest that you contact Mr. Donegan first. And
I spoke to him in the office last week, and he told me to come here to speak to you.
Bill, what was that in reference to?
It was about all of the items and issues that were surrounding the project, and my position was that they're coming to the board. He did notice about parking, or at least mentioned parking in the application, and I felt that it would be advantageous to try to work this out. But at any rate, yes, I did encourage Ms. Charles to come to the meeting and state her issues.
No, compliance with the prior resolutions, Bill, that's it. Whether there's compliance with the resolutions in effect. It's as simple as that. That's where we are.
Okay.
All right, thank you.
You're welcome. Ms. McKenna.
So does that mean compliance with the prior resolutions from the land use board that is itemized under the letter of May 14th, 2021?
I don't have that letter in front of me, so I can't say.
It's from Mott McDonald.
If there's an issue with compliance with the prior resolutions, then that should be brought to Mr. Donegan's attention. That's simply what we're saying. All we're dealing with is the new application. This board is not an enforcement board. We can't enforce the provisions. We have no power to do so.
Right, and the only mention of parking was in moving the dumpster that would add one parking space. It had nothing to do with any other parking.
Right.
So, so if you have an issue with anything at all, take it up with Mr. Donegan.
So what about the height of the sign structure that's
all prior
proposed?
Things that we had discussed and.
Okay, at the meetings that we were not given notice about?
Pardon?
At the meetings that we were not given notice about. Is that correct?
We can't go back, Mr. Chairman, we can't go back and reconstruct meetings. It's behind us. I don't know whether notice was given or not, but we're not going to revisit that. We can't revisit that.
So how do we appeal that?
You go to Mr. Donegan.
Give you legal advice.
And Mr. Donegan's role with the town is what?
He is our code enforcement officer.
Okay, thank you.
You're welcome. Anybody else? Would anybody else from the public like to ask the board any questions or make any comments? Anything at all? Ron, do you see anyone else?
No, sir, I don't.
Okay, seeing no one else, I will bring it back to the board. Is there any old business?
We doing on IDs?
The IDs are at the OEM building being printed, and as soon as we get them, we'll deliver them.
Thank you very much, Ron.
Sounds good.
Any other old business? Is there any new business?
Question, since we have some new members and we've changed members, Could we get a new roster and contact sheet made up?
Danielle?
Yep.
You know,
Okay.
class, et cetera, et cetera.
Okay. As I already mentioned, I will not be participating in the next meeting, and I may not participate in the meeting after that either. I'm not sure. It depends on how my recuperation goes. So Danielle will contact Mr. Ray and let him know. And if he can't be at the meeting, then the board will have to elect a temporary chairman for that time. Any other new business? Judy?
Judy's got to get unmuted. Unmute, Judy.
There we go.
I'm unmuted. I just want to wish you well with
Thank
any
you.
surgeries you have.
Thank you.
And I'm looking forward to seeing everybody in person very soon. But for now, meeting adjourned, please.
We are adjourned. Okay.
Hey,
Good night.